Hi guys, my name is Tara Marie and welcome to my channel True Crime Matters, where I talk about and analyze everything true crime. I have covered this Scott Peterson case at length, so I'm going to continue to do so because it is in the middle of a lot of very interesting things regarding the LA Innocence Project's motion that was submitted to the court earlier this year. In January of this year, 2024, the LA Innocence Project stunned many by filing a near 1,000-page motion declaring that they were representing Scott Peterson, found guilty of murdering his pregnant wife and child in 2002, saying they were investigating Scott's claim of actual innocence and that Scott's state and federal constitutional rights were violated. In the motion, the LA Innocence Project was mainly requesting that the DA allow them access to specific evidence from the time of trial, which they say Peterson has never had access to in over 20 years. They also requested to access certain pieces of evidence they wished to do DNA testing on. The Stanislaus County District Attorney finally submitted their written reply for DNA testing. In the filing, the DA requested that the court deny all requests, mainly claiming that there was overwhelming evidence of Scott Peterson's guilt in this case. They stated that Scott's recent legal maneuver was cobbled together and that there was no valid new evidence. However, the LA Innocence Project has just fired back with a near 200-page reply, which contains new evidence and information never before made public. Much of the LAIP's reply seems to focus on the notion that post-conviction counsel has identified considerable exculpatory evidence that appears to have been suppressed at the time of trial, as well as certain critical exculpatory evidence that was, quote, lost by prosecution and therefore never provided to the defense at the time of trial. And I can tell you, after reading through the LAIP's reply, I now completely understand what Paula Mitchell meant when she said in the status hearing back in March that her and her team noticed, quote, frankly, very alarming deficiencies in the discovery that was provided to the defense at the time of trial. And in their reply, the LAIP's stance is generally the idea that, quote, given the prosecution's certainty that Mr. Peterson is guilty, they should have no reason to oppose his efforts to conduct further investigation and provide him with the discovery and further DNA testing he seeks. On the other hand, if Mr. Peterson is innocent and did not harm or kill his family, as he maintains, the DNA testing requested could not only exonerate him, it could provide valuable leads to other suspects who may have committed these horrific crimes. Now, as a brief overview, here are some of the items the LAIP says were critical exculpatory evidence that was either lost or suppressed by the prosecution. Number one, the audio recorded calls between Sean Tenbrink and his brother Adam Tenbrink, wherein Lieutenant Aponte reported hearing Adam tell Sean that Stephen Todd was seen by Laci Peterson during the Medina burglary on the morning of December 24th, 2002, i.e., after Scott Peterson had left home for the day, which the prosecution claims is, quote, lost. And the later call between Sean Tenbrink and his mother, wherein Lieutenant Aponte reported hearing Sean tell his mother to tell Adam, quote, that the police had just interviewed him and he has to keep his mouth shut because he doesn't know who he's dealing with. Number two, the identity of the MPD officer or detective who interviewed Sean Tenbrink, police reports or notes documenting that interview, and any recordings made of that interview between MPD and Sean Tenbrink, an interview Lieutenant Aponte stated he believes was recorded. And number three, the videotaped interviews MPD conducted with Stephen Todd and Donald Glenn Pierce after their arrests on January 2nd, 2003, which were logged into evidence but never provided to the defense. Number four, reports of MPD witnesses interviews related to the Croton watch that was pawned on December 31st, 2002, and again on February 14th, 2003, which have never been provided to the defense. And number five, the video recording or partial video recording taken on Jean Ralston's boat on March 11, 2003, depicting what Mr. Ralston publicly stated he believed to be the body of Laci Peterson, located approximately 3 miles north of the location where Mr. Peterson fished. It says here the prosecution says a video camera was used to tape the monitor output directly and was partially successful. The defense was not provided with that partially successful videotape. And there are other things brought up in this document that personally I don't believe I've ever heard before, and I'm actually going to make separate videos for those because there's just so much and there's just so many. But for this video, I'm going to basically stick to and dive deeper into what I call the big one, probably the most obvious one if you've been following this case at all recently this year. The LAIP writes in their reply, quote, "In addition, consistent with this pattern of suppressing evidence and relevant to the instant DNA motion before the court, as the prosecution is well aware, the complete police file related to the vehicle fire involving the orange former Caltrans van was suppressed by the prosecution at the time of trial and was not discovered until a journalist tracked down fire investigator Brian Spitolsky in 2015, who informed him that there should be more photos in the file, which the journalist had to then obtain from an anonymous source. It was not until the journalist made Mr. Peterson's attorney aware of those photos that his counsel was able to request the files associated with this former Caltrans van fire from the Attorney General's office. Not until March 18th of 2016 was Mr. Peterson provided a more comprehensive investigation report prepared by Detective Grogan related to the van fire. And even then, Mr. Peterson was still not provided with the 6 photos of the burned van and blood-stained mattress that was part of a, quote, missing person investigation. Not until Mr. Peterson made a second request on July 19, 2016, asking for any color photos of the van, did the Stanislaus County District Attorney finally provide Mr. Peterson with the photos of the blood-stained mattress over 13 years after the photos were taken, at which time the prosecution agreed to conduct very limited DNA testing on the stained mattress fabric from the back of the van. Counsel's investigation into the original investigation in this case is obviously hampered by the purported, quote, loss and or suppression of evidence, some of which is described above. For all of these reasons, counsel filed the 2 motions currently pending before the court, seeking post-conviction discovery and DNA testing of physical items of evidence to further investigate Mr. Peterson's claim of innocence. Notwithstanding these challenges presented by suppressed, missing, and lost evidence, post-conviction counsel's investigation into the disappearance and murder of Laci and Connor Peterson has already yielded important leads to evidence supporting Mr. Peterson's claim that his wife was alive on December 24, 2002 when he left the home for the day and that he did not kill her. In the opposition to the DNA motion, the prosecution does not contend that the, quote, lost and suppressed evidence listed above and the other evidence Mr. Peterson seeks by way of the 2 motions pending before the court has been provided to the defense. Nor does the prosecution refute that many investigative failures infected the original investigation into the disappearance and deaths of Laci and Connor Peterson, as alleged in the instant DNA motion. Instead, the prosecution argues that the court should strike as, quote, inadmissible hearsay much of the evidence Mr. Peterson has presented, that Scott Peterson is not entitled to the discovery he requested in the DNA motion that would establish the availability and condition of the evidence he seeks to test, and that all of the concerns raised in the DNA motion before the court have been litigated and rejected. In other words, the prosecution is arguing that Mr. Peterson has not met his burden, showing that he is entitled to the DNA testing he seeks, while it continues its decades-long suppression of some of the very same discovery Mr. Peterson needs to investigate evidence he believes will support his claim that he did not harm or kill his family. And they later go on to say, regarding the state's opposition to DNA testing of these items, the prosecution argues that Mr. Peterson has, quote, failed to specify what specific types of testing that should be done for each and every item. This is incorrect. Mr. Peterson has met the pleading requirement, as he has identified both the evidence that should be tested and the specific type of DNA testing that should be done. DNA consultant Mihul Anjaria thoroughly explained in his declaration, submitted with the instant motion, the type of testing that would be conducted in the Serological Research Institute, the DNA testing laboratory where Mr. Peterson is requesting that the testing take place. The type of testing requested consists of 1, the Global Filer TM amplification kit coupled with a 3500 series genetic analyzer to achieve state-of-the-art DNA detection and discrimination powder, 2, probabilistic genotyping, and 3, should any samples contain an excess of female DNA compared to male DNA, SERI, S-E-R-I, can use the sensitive and male DNA-specific Y-Filer TM type kit to gain information on male contributors. Moreover, Mr. Peterson specified that on items of evidence where traditional DNA collection methods such as swabbing, cutting, and tape lifting is likely to be unsatisfactory, he requests that the court order the option for SERI to use MVAC technology to collect the evidence. The items of evidence sought to be tested have been identified to the best of Mr. Peterson's ability with the information he has been provided to date. Mr. Peterson is also requesting any previously extracted DNA on file in this case from Laci and Connor Peterson be provided to SERI so that an updated genetic profile can be obtained from the global filer without further sampling of evidence collected from remains. Now, again, about the orange Caltrans vehicle as related to the DNA testing, specifically items 1 through 4, the LAIP writes, the prosecution attempts to argue that Mr. Peterson failed to specify the type of testing to be done on the burned mattress because, quote, his own expert states that the first item for which DNA testing is sought, which is the burned mattress, may not be testable using the best sampling method because the mattress cuttings are burned and possibly brittle, so it may not be feasible to use the MVAC. This is a disingenuous argument at best, given that it fails to take Mr. Anjaria's entire statement from his declaration into consideration, which clarifies that the mattress cutting would need to be evaluated by the testing laboratory in order to determine whether swabbing or MVAC will be the best sampling method prior to testing. Mr. Peterson reasonably recognizes that final determinations on testing specifics included both sampling and typing methods are best made in a controlled laboratory environment where the exact current condition of the evidence can be assessed. Mr. Peterson requests that items 1 through 4 be tested using the methods laid out in the instant motion, and thus he has met the pleading requirement. And the LAIP continues, the prosecution contends that the orange van is, quote, completely unrelated to this case. It has no connection to this case, and that the van has never been connected to anything related to the case because, quote, no one ever saw an orange van. Those assertions are incorrect and misleading. The argument based on those incorrect statements is pure sophistry. There is ample evidence before the court that the police either failed to investigate whether the orange van was connected to the crimes in this case, or if the van was investigated and found to have some connection in this case, that evidence has been suppressed. The only thing that is certain is that the crime was not investigated and found to be completely unrelated to this case, as the prosecution maintains. The record in this case is clear. Evidence from the orange van was booked into the evidence under Modesto Police Department arson case number 02142-687, cross-referenced MPD case number 02142-591, the Peterson case. The prosecution has not refuted this fact in its opposition. In addition, the prosecution stipulated to DNA testing of this evidence in 2019, after it was discovered that evidence related to this vehicle fire investigation was suppressed at the time of Mr. Peterson's trial in 2004. Nor has the prosecution denied or even addressed the fact that the evidence envelopes for items 1 and 2 that are the subject of this motion are marked, quote, "Hold, do not destroy." The prosecution cannot possibly establish that the bright orange former Caltrans van fire in the airport district on Christmas morning is unrelated to the disappearance and murder of Laci and Connor Peterson at this stage, because as the prosecution has and must concede, police failed to investigate whether that van was related to Laci's disappearance and death. Moreover, Detective Shipley's report concerning the vehicle fire investigation, dated January 1st, 2003, is labeled, quote, "Missing Person Investigation," and it cross-references the MPD case number for the investigation into Laci Peterson's disappearance, and the prosecution previously stipulated to testing of items associated with this van. The prosecution cannot refute the fact that the orange van vehicle was related to Mr. Peterson's case because MPD's own files indicate as much. In addition, counsel for Mr. Peterson has presented this court with declarations by former MPD fire investigator Brian Spitolsky and retired ABC News producer George Michael Gudgel, who explain how it came to pass that it took 15 years for Mr. Peterson to learn that this evidence was suppressed by the prosecution at trial. After Mr. Peterson's counsel learned of the suppressed evidence on March 18, 2016, Detective Grogan prepared a more comprehensive investigative report related to the van fire and provided it to the defense. Even then, the prosecution still refused to turn over the 6 photos of the burned van and blood-stained mattress that was part of a, quote, "missing persons investigation." The prosecution has filed numerous objections to evidence described above, declarations by Spitolsky, Gudgel, and the report by its own MPD Detective Grogan, which the prosecution contends is irrelevant, among other declarations, in its ongoing effort to prevent the truth from coming to light about the MPD's investigations into the Medina burglary, the orange van vehicle fire, and the investigation into the disappearance and murder of Laci Peterson. Spitolsky and Gudgel both expressed sincere concerns in their declarations about the poor quality of police investigations involved in this case, and their concerns are well-founded. Side note, on top of Spitolsky and Gudgel, there was also a fellow law enforcement official, Lieutenant Aponte, who insists the MPD is suppressing audio tapes, but that's not related to the van, but I just wanted to mention it here. I'm trying to stick to one evidence point at a time. The LAIP continues. Mr. Peterson seeks DNA testing on items 1 through 4, which were collected from the crime scene in the airport district where the orange van was parked and set on fire. Item 1 is a piece of cloth from a mattress found in the back of the van. Item 2 is a piece of partially burned mattress cloth from the same mattress. Item 3 is a cloth recovered from what was sticking out of the van's fuel tank. And item 4 is a metal fuel container that was found on top of the mattress, protecting the stained fabric underneath it from being burned in the fire, and therefore possibly having blood transfer stains on the bottom of the container that could be DNA tested. DNA testing on the items recovered from the orange van could help establish whether or not the van was related to the crimes in this case. Should Laci Peterson's DNA be found anywhere on any items 1, 2, or 4, that would be irrefutable exculpatory evidence supporting Mr. Peterson's claim of innocence. In addition, genetic profiles obtained from item 3, if obtained, could be uploaded to CODIS and could identify a suspect or suspects involved in the theft of the van, and it could be determined whether there was any connection between that individual or individuals in the Medina burglary or the disappearance of Laci. In sum, if Mr. Peterson obtains favorable DNA results from testing any of these items, it is likely there would have been a more favorable result at trial. In addition, it is possible DNA testing the items from the van could establish the identity of the perpetrator or perpetrators of the crimes in this case, or a number of crimes, including who abducted and murdered Laci and Connor Peterson, who may have been an accomplice in the abduction and murder of Laci and Connor Peterson, whether there is DNA on the mattress that can be tied to a victim or victims of another crime or crimes, and who stole the van and who may have been an accomplice to the theft of the van, to name a few. Former MPD Fire Inspector Brian Spitulski stated in his declaration that he personally took the stained mattress fabric to the DOJ lab in Bryson for forensic testing in 2003, and that the forms associated with the testing contain errors, including that the samples were tested in front of him, which he states is false. The prosecution admits Mr. Spitulski examined the burned van and determined it was an incendiary fire, but objects to the opinions Mr. Spitulski expressed in his declaration about the evidence he examined as improper and irrelevant. The court should overrule those objections. Mr. Spitulski is a career fire investigator who has first-hand knowledge of the condition of the van he inspected and who is qualified to state his opinion about the evidence he examined. He was also a member of the prosecution team that investigated the van and possible connection to the disappearance of Laci Peterson, a fact the prosecution continues to steadfastly deny. The prosecution has not refuted that the police failed to investigate the following leads concerning whether the van fire that occurred the morning of December 25, 2002 may have been related to Laci's disappearance and death. And here they go on and on with these eyewitness statements related to an orange van. On December 26, 2002, Mike Chiavetta reported to MPD that on the morning of December 24, 2002, he saw that Peterson's dog and a bright orange blazer-type vehicle in East La Loma Park, at least 15 years old, and had square headlights, noticeable because of the bright orange color, which reminded him of a Caltrans vehicle. The prosecution does not deny that the police failed to interview Mr. Chiavetta about whether the bright orange vehicle he reported seeing, which reminded him of a Caltrans vehicle, was the same or similar to the bright orange van found on fire in the airport district the morning after Laci went missing, and which police determined was, in fact, a former Caltrans van registered to a man named Terry Borden, who used it as a company work van. The prosecution does not deny that police failed to investigate Mr. Chiavetta's statement that he thought he saw Laci and the Petersons' dog walking in La Loma Park the morning of December 24, 2002, nor did police show him photos of Laci or the Petersons' dog to confirm that he had, in fact, seen them in the park. On December 26, 2002, Mr. Chiavetta also reported seeing, quote, a gangbanger-type Hispanic male come out of the vehicle. Then there's a footnote here. It says, the prosecution attempts to justify MPD's failure to investigate Mr. Chiavetta's report about seeing a bright orange van parked in La Loma Park the morning of December 24th by pointing to the fact that he described it as an orange blazer. That argument is weak and unpersuasive. It is also disingenuous. The police report clearly states Mr. Chiavetta went on to describe the vehicle as, quote, at least 15 years old with square headlights, which was noticeable because of the bright orange color, which reminded him of a Caltrans vehicle. A description that is precisely the description that fits the van that was burned. The prosecution's argument is misleading and emblematic of its refusal to investigate Mr. Peterson's claim of innocence, which continues to be driven by confirmation bias rather than a search for the truth. The detailed description Mr. Chiavetta gave police of the van he saw, given the unique bright orange color, and his description that it reminded him of a Caltrans vehicle, leads to the conclusion that the van he saw is almost certainly the same van that was burned early in the morning in the airport district. The LAIP continues, the prosecution does not deny that police failed to interview Mr. Chiavetta about whether he would be able to identify the male he saw getting out of the bright orange vehicle the morning of December 24th. Nor did police ask him to provide a more detailed physical description of the man he saw getting out of the bright orange van. Then, on December 26, 2002, the same day Mike Chiavetta reported to MPD that he saw the Petersons' dog and the orange Caltrans vehicle in Loma Park, and that he saw Laci in the same park as well, eyewitness Diane Campos reported to MPD that she saw Laci Peterson walking her dog in Loma with two white males, and she saw that the dog was, quote, barking constantly for approximately 5 minutes while they walked the distance of approximately a football field or 100 yards. The prosecution does not deny that the police failed to investigate whether the, quote, gangbanger type Hispanic male Mr. Chiavetta saw getting out of the orange van bore any resemblance to either one of the two men Miss Campos saw trailing behind Laci in the park, one of whom she says was yelling at Laci, quote, shut the effing dog up. MPD also failed to investigate whether the, quote, Hispanic man Mr. Chiavetta saw near the orange van could be identified by the other witnesses who reported seeing dark-skinned or Hispanic men standing near the van seen parked in front of the Medina's home on December 24th. And there was 3 witnesses who claimed they saw that. Diane Jackson, Linda Chiles, who was actually the widow of an MPD detective, and Ninav T. Furthermore, the prosecution has not refuted that MPD failed to determine who stole the bright orange former Caltrans van that was set on fire in the airport district from its registered owner, Terry Borden. MPD failed to determine who burned or may have burned the orange Caltrans van in the airport district on December 25, 2002. MPD tested the stain on the mattress found in the back of the burned van, and it tested presumptively positive for blood. MPD failed to investigate, and the prosecution continues to refuse to investigate to this day whether it is possible to determine whose blood is on the stained mattress in the back of the Borden van, given the more sensitive and precise DNA testing technology that is available today. MPD failed to investigate whether any of the items they found at the home of Robert Smith, aka Bobby Riggs, the last known driver of the orange van, who was on probation for burglary, belonged to the Medinas or Laci Peterson. Mr. Peterson has established all of the above, described investigative failures supporting his request for DNA testing as on items 1 through 4, without relying on any statements the prosecution contends are objectionable as inadmissible hearsay. Mr. Peterson has made prima facie showing that favorable results from testing of items 1 through 4 would likely have resulted in a more favorable outcome at trial, had that evidence been available. And he has therefore met his pleading requirement. And I'm sorry if you hear bass right now. I live very close to a wedding venue, and it's getting to be the time where I think like a wedding is about to start. So sorry about that. We're getting to the end of this anyway, so I'm just gonna wrap it up. But I wanted to know what you thought about all of this. First of all, the argument made by the DA that the van fire and the missing persons case of Laci Peterson were completely unrelated and thus shouldn't be looked further into now. I agree with the LAIP. I don't quite understand the argument the DA has whatsoever, especially considering that they are admitting that it's an unsolved case. But what I find even more interesting about what the LAIP pointed out, the fact that it cannot be true what the DA is saying, that the van fire and Laci Peterson were never connected, because the police's own files have the two cases cross-referenced with each other. So the DA cannot refute the fact that the orange van was related to the investigation because their own files indicated that it was. Of course, we're hearing again about these witnesses, one of them being Mike in the park that saw a bright orange Caltrans van around the same time another witness reported seeing a golden retriever and a woman who looked like Laci in the park. That seems like it would or should have been further investigated, and to me, it's very troubling that it wasn't. But I think by far, from what I just read today, the most troubling information surrounding the burned van is the fact that it was only because an investigative journalist was digging around, 12 years after the trial, that this fire inspector found out just why he never heard about the van fire all these years. Not to mention the fact that those 6 photos of the interior of the van depicting the bloody mattress were missing from the police file, or the fact that it took the same journalist going to an anonymous source to obtain the photos. But even then, the most troubling fact of all is that even after all that, Scott Peterson's defense team still wasn't provided a copy of the complete police file. Like, come on. But here's the part that actually makes me kind of mad. After suppressing this evidence for so many years, which the defense should have been entitled to at the time of trial, they're still trying to deny him access to test it. I mean, to me, that is scary. And it's actually pretty infuriating. The whole idea of that speaks volumes to me. And the question remains, why wasn't this complete van fire police file handed over at trial if the cases are literally cross-referenced with each other? What do you think? Do you think the van is completely unrelated to this case and it's just another fruitless attempt by Scott Peterson to trick the court into believing his lies? Let me know what you all think in the comments section down below. As for me, I think this case is looking more and more like there have been some shady things going on over the years in Modesto with the DA's office and the MPD, and I'm not entirely convinced that Scott had anything to do with that shadiness the past few years. But that's really it for me today. Thank you so much for being so supportive and for watching. If you've gotten any use out of this video, please subscribe so we don't lose each other. It costs absolutely nothing and would mean so much for me to have your support along the way. Thank you so much for watching. Be careful out there.